Thank you so much, Dr. Paolo Freeman, for that speech. Now we move to the final paper speaker of this debate. So closing the case for the opposition tonight is Dr. León Castellanos-Jankiewicz. Dr. Castellanos-Jankiewicz is a senior researcher at the ASA Institute for International and European Law in The Hague. His work focuses on human rights, transitional justice, and minority protection. Previously, he was the Max Weber postdoctoral fellow at the European University Institute Florence and postdoctoral researcher at the Project on Memory Laws in European and Comparative Perspective. Dr. Castellanos-Jankiewicz, you have the floor.
Thank you, Madam President, and thank you, Mr. Outgoing President, for this very generous invitation. It's a pleasure to be here with you tonight. I come here today opposing the motion, but I arrive to my arguments from a slightly different direction today. I am no apologist for the arms industry, and in opposing the motion, I want to persuade you that the British arms industry ought to be held to account in the UK courts and not in the ICC in the beautiful city of The Hague. My job is to raise awareness about the human rights implications of irresponsible arms trade. And in this role, I believe that the International Criminal Court would have no jurisdiction to hear a case brought against the arms industry representatives of this country unless proceedings are brought against them here first. Going to the ICC today would not only be pointless from an accountability standpoint, worse even, it would mean foregoing the opportunity to exercise strict scrutiny over this high-risk industry under existing UK laws. We'd miss a chance to look at their negligent behavior and the way they operate. Unlike the motion's proponents, I believe that it is our duty in a moment to bring any negligent business to justice here first, and that the UK courts are perfectly capable of enforcing the rule of law. It is true that the UK has signed and ratified the Rome Statute of the International Criminal Court, and that as a result, UK nationals and residents could end up in The Hague to answer for core international crimes. But the ICC would have no jurisdiction over representatives of the British arms industry today because there have been no domestic cases or investigations attempting to bring these people to account here in the UK. In this case, justice at home takes priority, and let me briefly explain why. The ICC in The Hague operates on the basis of complementarity, which is embedded in its statutory and functional makeup. According to this important principle, states have the primary jurisdiction over any international crime committed by their nationals or on their soil. If domestic courts are unwilling or unable to prosecute, the ICC will step in. That is only when a country's justice system is broken, seriously compromised through the active undermining of fair trials and investigations, that's when the International Criminal Court comes to fill the gap. But the truth is, Madam President, yes?
It's a very, very sad state of affairs, but I have a friend who's just been arrested in Joshua Boyle for what should have been a 3-week sentence that has been put on a boa shop.
I'm sorry, I couldn't hear the question, the point.
I have a friend who's arrested for civil protest who was meant to be tried for 3 weeks and has been sentenced to 18 months. I'm afraid there really is a sinister element to protest crunch down in this country happening right now. That's why we're ranking next to Somalia in protest of freedom rankings.
Thank you. I come to the specific situations and examples in the UK later in my speech. The truth is, ladies and gentlemen, UK courts have been willing and able to exercise their jurisdiction to scrutinize UK arms exports. 2019, Liz Truss, then Secretary of State for International Trade, as she then was, revised the government's arms export assessment methodology in all credible incidents of concern. And this decision followed a Court of Appeal judgment which found that her office had not properly conducted risk assessments for UK arms exports to Saudi Arabia. And although these cases against government officials are important in securing transparency and have been brought forward by brave campaigners, some of whom are sitting in this chamber today, the reason why these cases against the UK government officials are not altogether relevant for today's motion is precisely because they've been brought against UK civil servants for their role in authorizing weapons sales. Crucially for us, they have not been brought against the arms industry companies and their executives for the downstream damage that their products are causing when they are on notice that atrocities are being committed with their goods. Other countries, such as Germany, are already doing this, and I will come to this later. For now, Madam President, let me emphasize that complementarity dictates that the arms industry be brought before the courts here first. These are UK executives. They can and should be tried by UK courts. And what is more, they should answer to the British public and this country's rule of law. The UK statute applicable to such cases is the 2001 International Criminal Court Act, which criminalizes the commission of war crimes, crimes against humanity, genocide, and aggression, effectively implementing that international instrument. Arms industry representatives can be held accountable against this act, which has been specially designed to cover international crimes and which has never been invoked against them. Not only does the act prescribe war crimes in the UK, it also has an extraterritorial scope, meaning it reaches acts occurring beyond UK borders and criminalizes aiding and abetting. UK laws sanctioning negligent arms sales are robust, yet they are underused. Last year, together with my students at the University of Amsterdam, students who are your age, not much older, I surveyed access to justice mechanisms for unlawful arms trade in 11 European jurisdictions. Our report is published. You can check it out online at the University of Amsterdam Law Clinic's page. And in the UK's case, we found that remedies in civil and criminal law had been underused or not used at all. And moreover, we concluded that these remedies would be highly effective, thus offering victims an opportunity to obtain redress. For example, if a private individual would violate the UK Export Control Act, they would face between 7 years and life imprisonment. So these industry players somehow are not on notice.
Point of information.
Yes.
But if these robust mechanisms have never been invoked, rather than a testament to their robustness, isn't that a testament to the need for the ICC to step in?
It is a testament, I believe, to the invisibility of the arms industry in this country, and the invisibility of the fact that they conduct their business undisturbed, and shunting them out to The Hague will not really bring them into account in front of the people, in front of the societies in which they act. It is more important for them, for us, to hold them to account according to our own standards, as opposed to relying on international courts. Just last month, I continue for now, and I would be happy to concede further points later. Just last month, I want to give an example. The Hague Court of Appeal ordered the Dutch government, example of justice being served in domestic courts about this very problem. The Hague Court of Appeal ordered the Dutch government to stop supplying Israel with F-35 fighter jet parts because there was a clear risk that serious violations of international humanitarian law would be committed with the aircraft in Gaza. The court applied Dutch law as well as international standards to reach its conclusions, effectively embracing the complementarity approach I have mentioned above. I move to my final points, Madam President. Prosecuting the arms industry at home or in the ICC for their contribution to war crimes and crimes against humanity is the tip of the iceberg. In my academic work, I've observed how disproportionate attention to situations of armed conflict has taken attention away from gun deaths in law enforcement situations. Up to 80% of gun deaths, crime deaths, worldwide occur outside armed conflicts. In everyday contexts, such as civilian mass shootings, which unfortunately are endemic now in the United States. But only about 20% or less of these deaths worldwide happen in wartime. I'm sorry, I will conclude now. I have 1 minute left. This is why lawsuits in the US and Germany, for instance, have focused on suing members of the arms industry for their negligent or alleged criminal contributions to the spread of endemic violence in societies and for enabling and arming transnational organized crime networks and drug cartels with ever-increasing power. In the US, back in 2021, Mexico recently sued Smith & Wesson and 6 other gun makers in federal court for allegedly aiding and abetting in the trafficking of firearms. And guess what? In the past 2 years, gun deaths have gone down in Mexico. In Germany, Heckler & Koch, 6 Sauer, were held responsible in that country's courts for breaking administrative and trade laws through unlawful exports to Mexico and Colombia, and were required to pay back the earnings from those exports to the state. To conclude, Mr. Speaker, the biggest challenge, I believe, is not just that of bringing negligent members of the arms industry to account in the UK courts. Rather, it involves upholding our domestic rule of law against ourselves, not just against petty foreign dictators and war criminals such as Augusto Pinochet. Moreover, let us not outsource the administration of justice when our institutions can withstand the pressure. In short, let us abide by the visions of a fair society that we have created and hold ourselves accountable when we fail to do so. That is why I ask this House to vote against the motion. Thank you, Madam President.
Thank you so much. And with that, our debate tonight concludes. So one notice from me before we vote, that is that the Easter Garden Party tickets will go on sale over vacation. So please do keep an eye out on our social media. It promises to be a really fun kind of evening. So now we move to vote. Could the tellers please take their positions? So as you know, in this house, we vote with our feet. Ayes to the right, noes to the left, and abstentions down the middle. The result of the debate will be announced in the bar afterwards, so please do join us in the orator for some post-debate drinks. Could we end with one last round of applause for all those that contributed?